slides about how to contact our intake line with more specific questions about your specific situation. So with those things said, I'll get started. So my name is Rachel Funk. I'm a staff attorney or supervising attorney now, I guess, in the LAOP project, Legal Assistance for Older People at Southern Minnesota Regional Legal Services. And I'm giving this presentation on October 29th, 2024. So this information is current as of today. Okay. So the Legal Advocacy for Older People project at SMERLS provides free legal help on critical legal issues facing seniors age 60 and over in our service area. So the SMERLS service area is 33 counties from the Iowa border up to the Twin Cities, basically. We are funded under the Federal Older Americans Act. And as a result of that funding, we do not do means testing, which means we do not look at a client's income and assets as a way to determine whether we can help that person. Instead, what we do is we look at the issues that face seniors age 60 and over in the greatest social and economic need. And so if a potential client is contacting us about an issue that affects people age 60 and over in the greatest social and economic need that they're facing, then we will look at their case to see if we can represent them, whether or not their income and assets are different from what other requirements may be at the SMERLS program. For intake, to reach out to SMERLS and do a client intake to see if your case can get advice or representation, telephone is the most efficient way at this point for prospective new clients to connect with us. So I've put our intake 877 number here. Our intake lines are open from 9 a.m. to 3 p.m. There is usually a break at lunchtime because the intake workers do need a break in the middle of the day. And the intake is not available on weekends or holidays. If that time frame does not work for you for any reason, you can also do an online intake at any time of the day at lawhelpmn.org. When you do that online intake, we receive an electronic communication that you're looking for legal assistance, and then our intake office reaches out during our intake hours to complete the actual intake. During intake, we do collect information over the phone. So potential clients should be prepared to provide a non-attorney staff member information about themselves, which will include the name, the date of birth, the telephone number, the address, and a basic description of the legal problem. Those items of information are required for us to be able to evaluate the case to see if we can provide representation or advice. SMERLS provides language accessibility to clients or callers who do not speak English as a primary language. We have personnel who speak Hmong, Spanish, Somali, and other languages commonly spoken by our clients besides English. If a caller speaks a language that we do not have a staff person who's fluent in, then we use Language Line to provide interpretation services. Any interpretation service that we provide is at no cost to the client. So a potential client does not need to wait until they have arranged for their own interpreter to reach out to us. The person can reach out to us in their language of choice, and we will organize either to have a staff member provide interpreting or Language Line. Okay, so that is SMERLS in a nutshell. To move on now, we'll be talking about grandparent custody and visitation rights in Minnesota. So I will be going through grandparent visitation, grandparent custody, and alternative arrangements. Just as a bit of a disclaimer, of course, SMERLS is in Minnesota, and family law issues in particular are almost always governed by state law. So what I'm going to be discussing today is really only applicable in Minnesota for Minnesota residents and Minnesota children who are in Minnesota. I also wanted to start by kind of level setting a little bit in talking about grandparent rights. So under the Constitution, the United States Constitution and Minnesota law, only parents have a right to visitation and or custody of their children, and parents have the constitutional right to the care, custody, and control of their children, including who can visit their children. That is a fundamental constitutional right that parents hold. Grandparents and other people do not have any constitutional right or other right to spend time with their grandchildren in Minnesota. However, in certain circumstances, which is what I'm going to be talking about today, non-parental figures, including grandparents, can ask the court to allow visitation or custody in a court order. So I just wanted to set that framework to help understand how the statutes are set up to allow grandparents and other interested parties to ask for visitation or custody, knowing that at the basis of it is a constitutional parental right to make decisions about visitors. Okay, so grandparent visitation, I'm going to talk about first. I'm going to go through who can request grandparent visitation, how to file for grandparent visitation, what proofs are required, and the standard that courts use in determining whether they are going to grant grandparent visitation and to what degree or extent. Okay, so I apologize for this very wordy slide. I wanted to put everything on one slide for reference. And I did want to include also the citations to the Minnesota laws that are relevant. So I say grandparent visitation, and I'm talking about, grandparent visitation and grandparent custody. But it's important to note also that these rules are not exclusive to grandparents. Some of these statutes allow people who are not grandparents, not relatives at all, to ask for the same type of court order. And I've tried to specify when it's something that is specific to a grandparent, when it's something that a different family member or other interested party can request. So to be able to request a court order grandparent visitation, the grandparent has to have what's called standing, which basically means that the grandparent has to demonstrate they have the right to ask this question of the court at all. There are very specific circumstances where a grandparent or other person will have that right to even ask for visitation with a child. Those situations are if a parent of an unmarried minor child is deceased, that's under the statute. If there is or has been a family court case that's been opened, such as a divorce case, a custody case, a separation case, or a paternity matter, up until the child reaches majority age or age 18. So it doesn't have to be a currently open family court case. If a family court case was opened at any time and the child is still under the age of 18, then the grandparent can petition or file a motion to request visitation time with that child. Another circumstance where a grandparent or a great-grandparent can have standing is if the child has resided with the grandparent or great-grandparents for 12 months or more and is then removed from that household by the parents. So if a grandparent or great-grandparent has had a child living with them for 12 months or more, and then for some reason the parents remove that child, in that circumstance, the grandparent can request or great-grandparent can request that the court allow visitation. If the child has lived with anyone, so it doesn't have to be a family member or a relative in any way, anyone other than a foster parent for 2 years or longer, and the child no longer resides with that person, then that person also would have standing to go to court and ask the court to grant visitation for that child. And then the final circumstance is if the child was adopted by a step-parent and the grandparent's child, the parent of that child, has died or had their parental rights terminated because of the adoption, then that grandparent can go to court and request visitation. So that's also a very particular circumstance as well. I wrote at the top here, these are situations where the grandparent can have standing. These are the situations that are stated in statutes that allow grandparents to have standing. I only sort of put a bit of a caveat on it because the court does have to find in making a visitation order that the grandparent did prove that they had standing. Okay, so once now we've covered standing, and I know that that is a lot of information. But if you feel that you do have standing to request visitation for a grandchild or other child based on the circumstance you're in, then here's some information about how to file for it. To request grandparent visitation, you have to be asking for a court order. So the grandparent or other party has to file what's called a petition or a motion with the court. A petition is to start an action asking for visitation. A motion is a request that's made in an already filed case. So I'm going to go back to the previous slide just for examples here. In the first example of a grandparent standing when a parent of the unmarried minor child has unfortunately died, there's not an open case related to that, so a petition would need to be filed to start a case to request visitation. If there has been, the second example, if there has been a family court case like a divorce or a custody matter, then the grandparent would not be filing a petition because you're not starting a new case. You're filing a motion in that already filed case. So that's kind of the difference there. The Minnesota Courts website does have a lot of forms related to family court cases and other cases. So I have put the link here for how to get the generic motion forms for family court cases. And then I'll have a link later related to the actual custody forms. Those forms are also online as well. So I really do recommend if you want to be filing a motion or a petition, go to the Minnesota Courts forms self-help section, and you can browse around to see what kinds of forms they have. The law libraries are also a great resource for finding the forms that you can use to make these motions on your own behalf. You can also consult an attorney to see if the attorney can help you with those forms. But a lot of these forms are available for you to be able to fill out on your own pretty easily. If you are going to file a petition or motion for grandparent visitation, then you have to serve that petition or motion along with a notice of when that petition or motion is going to be heard by the court. Service is a term of art. It's a specific term. And what it means in Minnesota is that the documents are personally given by someone who is not involved in the case to the relevant person. So if you as a grandparent are filing a petition or motion for visitation, you are not able to hand that paperwork to the parents involved and have that be valid service. It has to be someone who's age 18 or over who's not involved in the case. Oftentimes you can hire a company to a process service company. And I would recommend that if you have the funds, just because they're very familiar with how to do service. And, usually they'll do the affidavit to confirm that they've properly served the person, pretty seamlessly. You have to serve the motion or petition on, all of the interested people. So if the child is living with their parent or has a parent, you need to file it with the parents. I have put a citation here for looking at the different sort of definitions of parent in Minnesota law. It doesn't have to be a parent that the child is living with. It doesn't have to be necessarily a parent that's on the birth certificate. The parent is a pretty broad term, and I think the idea in the statute is for you to be notifying really anybody that could be considered a parent under the law. You also need to notify or provide service to the guardian or legal custodian of the child if that's different from the parent, and the child's tribe if the child is a member of a Native American tribe under the Indian Child Welfare Act. Okay, so once you have filed the grandparent visitation petition or motion, what is it that you have to show the court to convince the court to actually award you the visitation that you're asking for? Apologize for shifting myself around here. There are essentially two main prongs that a grandparent or petitioner has to show for visitation to be granted. First is that the visitation would be in the best interests of the child, and second is that the visitation would not interfere with the parent-child relationship. Both of these things must be proven by what's called clear and convincing evidence. So again, I want to go back to remind you that if you're in court requesting that the court give you visitation rights, that means that the parents who have the constitutional right to determine visitors for their children have declined to give you that visitation. That for some reason the parents are not allowing you to visit this grandchild, and so you are going to the court to override the parents' wishes and get the court to order visitation. So to override what the parent's constitutional right is here, these are the two things that you have to show by clear and convincing evidence, which is a pretty high evidence standard. In the next slide, I'll talk about the different evidence standards. So there are a number of different standards of evidence that we use in the law typically. I've written them here in ascending order. So substantial evidence is defined as more than a scintilla. Usually, substantial evidence, it comes up in appeals of agency fact-finding. If a court of appeal is looking at a decision that an agency made, then the Court of Appeals is looking for substantial evidence to determine whether that agency fact-finding was correct. So it doesn't have to be a huge amount, just more than a little bit. Preponderance of the evidence means that the evidence is showing that whatever the allegation is more likely than not, or 51% towards whatever the allegation is. That is the usual standard of evidence in most civil court cases. So if, for example, someone files a lawsuit against someone else saying that that person owes them money for work done or something like that, then the court is going to ask you to prove more likely than not that this person does actually owe you that money. Clear and convincing evidence, which is what's required for grandparent custody to be awarded, is more than a preponderance, but less than beyond a reasonable doubt, which is the usual context for criminal matters, or the usual standard of evidence for criminal matters. So another way to say it is that it's highly probable. None of these standards of evidence are scientific or really quantifiable. I mean, I know preponderance of the evidence, we said 51%, but that basically means that if the evidence ties, then whoever is supposed to show their proof doesn't win. But I think it's important to know that clear and convincing evidence is a pretty high standard of evidence. It's not as high as in a criminal case, but it is still a pretty high standard of evidence for the grandparent to show that, again, going back, the visitation would be in the best interests of the child and that the visitation would not interfere with the parent-child relationship. Other considerations that the court will undergo in assessing a grandparent visitation application is the amount of personal contact between the parents or grandparents and the child before the motion or petition for grandparent visitation was filed. And they're also going to consider the reasons that the parent has for denying the grandparent visitation. So when a grandparent files for visitation in the trial or hearing about that application, a lot of these details about the relationships among all of the people will be part of what the court is considering and part of the evidence as well. Okay, so I said best interest of the child a few different times. I know. So here's sort of the definition. It's important to note that in really all kinds of cases relating to children, the best interest of the child standard is frequently the language that's used, but it does mean different things in different contexts. In the visitation context, it's not defined with specific criteria or specific factors, but it does require the court to balance multiple different types of information, multiple different considerations, like, for example, the amount of contact between the grandparents and the grandchild, or the parents and the child, and the reasons. So it does require the court to delve into details of the relationships again, and it can also include consideration of the child's wishes, but it doesn't necessarily have to. It really depends on what's appropriate in that circumstance based on the age of the child, the education of the child, different kinds of considerations for whether the child, is able to make their wishes known and the reasons why. And these are all things that the court is going to decide whether they're relevant to this child's wishes. And again, the grandparent to be awarded the visitation has to show by clear and convincing evidence that, factoring in all of these different details, it's in the best interest of the child to be awarded for the grandparent to be awarded the visitation. As far as the second prong, interference with the parent-child relationship, again, it has to be shown by clear and convincing evidence. And this is, again, a very fact-specific inquiry that the court undergoes. This case that I put a citation to here, in this particular case from about 15 years ago, the court ended up finding that the amount of visitation with the grandparent, which I believe was a couple of days a week and then every other weekend, so kind of similar to what a parent might receive, the court found that that amount of visitation in and of itself interfered with the parent-child relationship. So the court is going to be looking at how much visitation is being requested, what is the ongoing relationship between the grandparent and the parent, the grandparent and the child, the parent and the child. Are there issues in those relationships that might lead to interference with the parent-child relationship? They're going to be looking at all of that information to determine whether the grandparent has shown by clear and convincing evidence that visitation would not interfere with the parent-child relationship. Okay. So next, I'm going to be talking about grandparent custody. And again, I'm going to talk about who can file, how to file for custody, the proofs that are required, and the standard for the court in evaluating these grandparent custody cases. Once again, although I'm saying grandparent and we're talking about grandparents, the custody, the non-parental custody statutes are not specific to grandparents. So anyone who falls within the custody standing, regardless of their biological relationship to the child, can request standing under these statutes. So you do not have to be a grandparent, but if you are a grandparent and you want to seek custody, then you have to go about it through this particular statute. To have standing for custody, you have to be what's called a de facto custodian or an interested third party. Both of those things are defined in the statutes. So to start off, de facto custodian is defined in the citation here, the statute here that I put, and it is defined as the child's primary caretaker where the parents are not consistently involved. And what that means in the statute is that, for example, the parents not providing food, clothing, shelter, health care, education, nurturing, just consistency, or other types of care that are required for emotional and physical development of the child, or other types of neglect. It's a non-exclusive list. Those are just examples of circumstances where the parent is not consistently involved, such that this person is a de facto custodian. And to be a de facto custodian, the child has to have lived with that person without the parent there for 6 months or more if the child is less than 3 years old, 1 year or more if the child is 3 years or older, and must have met those time requirements before filing for custody. It does not have to be consecutive time periods. So if a child who's less than 3 years old lived with a grandparent for 2 months and then didn't for a month and then back for 3 months and then went away for another 2 months and then came back for another month, that would meet the 6 month duration requirement. So it doesn't have to be consecutive. But again, the parent can't be living there as well. And the parent also cannot be consistently involved during that time period. And the time period has to be met before any action has been filed by the grandparent to ask for custody. So you don't get to kind of add up the time after filing for custody to meet this requirement. As we talked about before, the standard of proof for a person to show that they are a de facto custodian is clear and convincing evidence. So again, that's that higher standard of evidence that's not to the level of beyond a reasonable doubt, but is more than a preponderance of the evidence. To show, oops, I'm sorry, that's a repeat there. So the proof for a de facto custodian to show that they should get custody is clear and convincing evidence that that person qualifies as a de facto custodian and a preponderance of the evidence that being in the custody of that person is in the best interests of the child. So that's that slightly lower standard of proof, preponderance of the evidence, which is the more likely or not that being in the custody of the person is in the best interests of the child. The court is required to consider a number of things when they're looking at these cases. The statute says specifically that the court has to consider these factors. So, one of the first things the court has to look at is what was the parent's intent in leaving the child with the person who is the de facto custodian? So, was the parent leaving the child there for a specific reason and maybe something happened? Was the parent, did the parent not really have any intent? Was the parent planning to live there themselves? The court, again, it's very fact specific, and the court is going to look at all of those facts and just determine what the parental intent and consider that as part of their evaluation of the best interests. The court is also going to consider the amount of parental involvement during that absence. So, a parent who is frequently in contact, who is still very involved, even while they're physically absent, that's going to be a factor that the court is going to determine in determining whether it's a de facto custodian involved. They're also going to look at, again, the reasons that the parent was absent. Was the parent ill for some reason and they couldn't have been present? Was there, some other situation that prevented the parent from being present, or was it something that was under the parent's control? The court is also going to look at the parent's cooperation or lack of cooperation with any court orders relating to custody conditions. So sometimes in a custody case, if there's, for example, a removal if a child's removed from a home, the court may order that the parent comply with certain conditions in order to retain or to get back custody. And in a de facto custodian petition for custody, the court's going to look at whether the parent cooperated with those court orders related to their custody conditions or if they didn't. The court's also required by statute to look at whether domestic violence prevented the parent from seeking custody earlier. If there's if this is a question of a de facto custodian versus a parent seeking custody, the court's going to consider whether domestic violence was part of the reason that the parent wasn't able to be as involved. And the court is going to look at where the child's siblings are living. So if the child's siblings are living also with the de facto custodian, that might be a point in the de facto custodian's favor. If they're living somewhere else, it might be a point against the de facto custodian or towards wherever the siblings are. But again, there's the statute does not say each of these have to be checked off, and then that's how the court is going to decide where the child goes or who has custody. These are just the court has to balance all of these different factors in looking at a de facto custodian's petition for custody. And they will use these factors in determining whether the person is a de facto custodian and also, what the best interest of the child is. Interested third parties, I'm going to pop back a little bit because I know it's a lot of information. So just as a reminder, the two types of standing to request custody when you're not a parent are that you're a de facto custodian or an interested third party. So an interested third party is defined as not a de facto custodian. The person does not have to have a particular relationship to the child, and an interested third party cannot have been convicted of one of a list of crimes in the last 5 years, or still be on probation or serving a sentence for that crime, or have ever been convicted of that crime against a family or household member. The list of crimes, I put the statute there. It's kind of what you would expect, like crimes where you've committed a significant harm against another person. If you've been convicted of a crime like that in the last 5 years, or if you've ever been convicted of a crime like that against a family or household member, then you're not going to qualify as an interested third party to be able to seek custody of a child who's not yours. To prove that the interested third party should have custody, the interested third party has to prove that by clear and convincing evidence, again, that the parent has abandoned, neglected, or otherwise shown that it would be harmful for the child to live with that parent. So that it would be harmful to the child to be living with that parent, or presence of physical or emotional danger to the child means that placement takes priority over the parent-child daily relationship. So if you remember when we were talking about grandparent visitation, there's that constitutional right to the parent to make decisions about the child, and the court is very concerned in those cases about interfering with the parent-child relationship. So kind of similar to that, to prove that an interested third party should be able to have custody over a child, they should have to prove either that the parents abandoned that child or it would be harmful for the child to live with that person, or that there's such a significant physical or emotional danger to the child that figuring out where that child should live takes priority over preserving the parent-child relationship on a day-to-day basis, or other extraordinary circumstances exist. So that has to be proven by clear and convincing evidence, and then also by a preponderance of the evidence that it's in the best interests of the child to be with the interested third party who's asking for custody. So again, the statute does say specifically what the court is required to consider in determining whether an interested third party should be awarded custody. They have to consider the amount of involvement between the interested third party and the child. So like I mentioned before, there's no specific relationship that's required, but the court is going to look at how much time, how much of a relationship this interested third party and the child have. The court's also going to look at the amount of involvement of the parent during their absence. So even if the interested third party has shown that the parent was absent, the court is still going to look at what was the involvement of the parent during that absence, much like with a de facto custodian. They're also going to look at the amount of involvement of other interested third parties. So there could be other people who are also wanting custody who are not parents, and the court's going to balance, what is the involvement of these other people with this child. The court's again going to look at the reasons that the parent was absent. They're going to look at whether the parent has been cooperating with any court orders related to custody conditions. They're going to look again at whether domestic violence prevented the parent from trying to get their own custody earlier. They're going to look at where the siblings are living, and they're going to look at whether there's what's called a standby custody designation, or what you might consider a godparent. So has the parent put something in a legal document previously about who they would want to have custody of their children if they weren't able to have their own custody? The court's going to look at that too to determine whether that should be a factor as well. Well, it should be a factor. They'll look at how it balances against the other factors. And again, just like I mentioned before, It's not a checklist. It's not, you do half of these and you win, or you do less than half and you don't win. It really has to do with just the court balancing all the different facts and looking at all these different considerations to try to decide what's in the best interest of the child. As I mentioned before, best interest of the child is a standard that gets said a lot and applies in a lot of different legal matters relating to kids under Minnesota law, and it can mean different things in different contexts. So in the third-party custody context, it is specifically defined as the balancing among 12 different factors that the court is required to consider in determining the best interest. I didn't write all 12 factors here, but you can go look at the statute if you want to. I think some of the big ones, I mean, they're all big, but some of the ones I wanted to highlight is the mental and physical health of all of the individuals involved. So that's the person who's petitioning for custody, that's the parent, that's the child themselves. The mental and physical health of everyone involved is a factor in determining the best interest of the child. The child's cultural background is also an important point in determining the best interest of the child. The reasonable preference of the child, if applicable, again, same as before, a child that's too young or for some other reason is not able to express their own preference, that's not going to be as much of a factor. But if the child does have a preference and can express it, then that's something that the court should consider as well. And one of the factors also includes interaction and interrelationship of the child with anyone who may significantly alter their best interests. So that's, again, I just wanted to highlight that because I wanted to show how broad this inquiry can be in determining what the best interest of the child is and how much information the court is going to want. No single factor can decide best interest. The court is required to consider all 12 of the factors. And in addition, if the third party is seeking joint custody, then the court also has to consider additional factors, including the ability of the parties to cooperate with each other. So if two or more people are looking to share custody of a child, one of the factors that the court looks at is, are those folks going to be able to cooperate with each other well to improve or in order to be in the best interest of the child. And if it seems like they can't, that will be a factor that the court will consider in looking at whether to grant that custody order. Okay. So how to file for grandparent custody or third-party custody. Similar to the visitation, you have to file either a petition or a motion, depending on whether there's a court case already active. There are, the link here for the different forms. And again, the petition or motion has to be served by someone who's not in the case on basically all of the people that are interested in that child themselves. So the parents, the guardian or legal custodian, the child's tribe, if that's applicable. And I think actually, here we go. Sorry, this one is a duplicate of the previous, but this one has, before we send it out, I'll take that slide out. There are, as I mentioned, the Minnesota Courts website does have a specific section for third-party custody forms. So you can go there and you can find all of the forms that are required to file a petition for third-party custody. And the forms also include instructions as well. The law library is a great place to get some help finding those forms. The self-help centers at the different courthouses also are a great place to go to get those forms to fill out. Okay. So in the last little bit, I also want to talk about alternatives and other considerations when you're looking at trying to get court ordered when you're in a circumstance where you're thinking about asking a court to give visitation or custody of your grandchild. Some of these I don't have a specific slide about, but I am going to talk about mediation and conflict resolution. Family therapy, I think, can also be really helpful, although I don't have a specific slide about that. A designation of parentage, I'll talk about what that is. And then I also again, don't have a slide about it, but I did want to make a note here that if you do have custody of a child through third-party custody, there can be some programs that are available to you for some assistance from the government for caring for that child, depending on that child. And if you receive assistance like that, that should not affect your own public benefits if you receive benefits. So I want to start first by talking about the designation of parental authority, or DOPA. You might have heard the phrase DOPA before. It's a legal document. It is a document that's signed by the parent and notarized, and it gives permission to another person, not the parent, to make decisions about the child, including medical care and treatment and school registration and enrollment. It doesn't transfer or doesn't give authority to make, every decision about the child. So someone with a DOPA would not, for example, be able to give permission for a minor to get married. But it does allow a person who's not a parent to make those kinds of day-to-day decisions that often need to be made, even when there's, not when there is a parent who's also involved. So it doesn't remove the parent's authority to also make these decisions. Instead, it adds this person as another person who can make decisions about the child. DOPA automatically expires in 1 year, but it can, if you want to, you can write in it that it expires earlier. It can be revoked by the parent at any time in writing, and both parents do not need to sign the DOPA, but the non-signing parent does have to receive a copy within 30 days with some exceptions that I won't go into here. The Law Help MN website has a free tool that you can use if you're interested in making a DOPA, or if you want to talk to your grandparents' parents about having a DOPA. That tool can help you draft it and get a DOPA that meets your needs. What I think the benefit of a DOPA, there are a lot of benefits, but one of the things that I think we hear frequently from grandparents who are caring for their grandkids and the parent has had to be absent for some reason, is that everything's fine on a day-to-day basis until they need to take the kid to the doctor. And then all of a sudden, because the parent's not there, the grandparent is not able to do what they need to do to care for that child appropriately. And I think that can lead to a lot of conflict between the parents and the grandparents, because the grandparents feel like they've been kind of, left out to dry. They want to get the kids help. And then sometimes the parents might feel like the grandparents overstepping. So doing a designation of parental authority, if a grandparent is going to be caring for a child, on a longer term basis and the parent's going to be gone, it can be really, really beneficial, and it can help to avoid some of those conflicts that might then later lead to a court action. And I just, as a person who likes to do things ahead of time, it's, I think, just very helpful to have that conversation between the parent and the grandparent about what kinds of authority will be designated in the DOPA, and what the grandparent is able to do to care for the child, just to know in advance and try to avoid some of those conflicts down the road. Another good way to try to stay out of court is through mediation or conflict resolution. I will say, as I have in the first part here, oftentimes if you do bring a case in court, the judge might order mediation or conflict resolution before you do a trial in the case, because the judge might think that it's something that could be resolved in mediation, and they at least want you to try to resolve it in mediation before you go through the whole trial. But you don't need to have an open court case to be able to seek mediation. There are a number of different agencies and companies that do mediation for people who are just looking to resolve some kind of situation between or among them. Mediation is a confidential process. It's guided by professionals, and it's geared towards resolution on the party's own terms. So rather than asking a court to impose a resolution and say, here's what the court decides is going to happen in this case, mediation is geared towards the parties coming up with a resolution that works for both of them. or at least is tolerable by both of them. Mediation is not legal advice and it is not legal representation. So the mediator is a neutral third party who does not give legal advice to the participants and is not representing the participants. Confidentiality in mediation is governed by statute also. And in specific, the statutes provide that witnesses in a court hearing cannot be someone who cannot be asked about a communication or a document, including work notes made or used in the course of a mediation pursuant to an agreement to mediate. So basically what that means is that if you go into mediation, you've agreed to mediate and you're going into mediation, if that breaks down for some reason and you can't come to an agreement, you don't go to court and then start asking for the other person to give a lot of testimony about what they were talking about in mediation. And you can't ask the mediator to come to be a witness for your court case. There are some exceptions to that. So, for example, if you're going to court because you're trying to change the mediation agreement or set aside the mediation agreement for some reason, then you may need to be able to do some testimony about the mediation itself, or if the document or testimony is otherwise discoverable. So if somebody brings a letter into mediation that they have already sent to you, that doesn't mean that that letter is now protected from being in a court case. If you could otherwise have it, then it can still be used in the court case. But the idea here about mediation confidentiality, like with all kind of settlement discussions, is that the parties should not be trying to gain an edge or gain an advantage by going to mediation. The point of mediation is really to try to resolve the problem without needing to go to court. So the confidentiality rules are set up to make that process as open and honest as possible to come to a resolution. There are a couple different mediation and conflict resolution agencies here that Law Help MN has highlighted. So I wanted to put them in our presentation as well. So there's the Conflict Resolution Center, which provides in-person or online sessions, and it does provide low-cost and no-cost services in certain circumstances. There's also a Dispute Resolution Center, which covers people who are in Dakota, Ramsey, or Washington counties only. They also provide in-person and online sessions, and they have a sliding scale fee. If you're in a court case and the court orders mediation, then the court order will specify how it's going to get paid for and who pays for it. So that's something that the court will tell you if you have to pay for it, and then either the court will refer you to a specific agency or you'll have to find your own mediation agency. I do really recommend seeking out this kind of resolution before you think about going to court. Just kind of to sum up, this is the last slide in the deck here, but just to sum up, going to court and seeking a visitation over a parent's objection or seeking custody of a child, it can be an extremely lengthy, extremely difficult, and emotionally draining process for everyone involved, including the kids. So if you're able to come to an agreement without having to go through that whole process, I really, really do recommend it. Going to mediation doesn't mean that you're saying you would never go to court. It just means that you're trying to resolve the situation in a way that works best for everybody who's involved in the family, to at least try to make it more workable. And that's it. That's the presentation. I've got here again the intake number, the office number for our central office. And then just as a note, our Legal Advocacy for Older People project is funded under contract with the Minnesota River Area on Aging, Southeastern Minnesota Area Agency on Aging and Trellis as part of the Older Americans Act. So thanks everybody for listening to this long presentation.
Yeah, that was a fantastic, Rachel. Thanks very much for that. But yeah, before we get going here, yeah, let's see if there's any questions in the chat. If you do have any questions in the chat, feel free to type them right now. We do have a little bit of time left over here, and then we can continue on. So, seeing a couple thank yous. Let's see.
I'm going to stop sharing so I can see the chat too if there's a
Sounds good.
okay.
And
Um, yeah, and
not
for anyone, again, anyone who's watching this recording, if you do have a specific question, please feel free to reach out to our intake. We do have attorneys that can give advice over the phone pretty quickly if it's something like that, or it could be referred to our unit to see if we could provide representation.
Perfect. Yeah, but yeah, in the absence of seeing any questions, Rachel, I think we can go ahead and call it a day here. So yeah, again, thank everybody for coming. And if you're watching this recording, thank you so much for taking the time to check us out. And yeah, hopefully we will see you in next month's presentation. So, all right, take care,
Thanks.
everybody.
Bye.